Police officers are among the most visible symbols of government power. They stop vehicles, they detain individuals, they search property, they use force, and in extreme cases, they take lives. For many Americans, police encounters are the moment when the law stops being theoretical and becomes personal. Yet most people do not actually know what police are legally allowed to do. They rely on assumptions, movies, or social media clips. In this episode, we are going to replace assumptions with law, not opinion, not emotion, not politics, just legal reality. Welcome to American Laws Explained, where we break down U.S. laws, rights, and government power in clear, plain English. This episode is for educational purposes only. It does not provide legal advice. Laws vary by state, and specific facts can change legal outcomes. Our goal is understanding, not instruction. Before we discuss limits, we need to understand why police power exists. In American law, police are agents of the state. Their purpose is to enforce laws passed by legislatures, maintain public order, protect life and property. They do not create laws, they do not interpret laws, they enforce them. But enforcement requires authority, and authority requires limits. Police power comes from the Constitution. Police authority does not exist independently. It flows from state constitutions, state statutes, and ultimately, the United States Constitution. The Constitution allows government to enforce laws, but restricts how that enforcement happens. Every police action exists inside that balance. Every police encounter revolves around one legal question. Was the officer's action reasonable under the Constitution? Not perfect. Not ideal. Not polite. Reasonable. This single standard shapes almost every police-related court decision in America. Police officers have discretion. Discretion means choosing when to stop, choosing when to warn, choosing when to arrest, choosing how to respond. Discretion is not unlimited, but it is broad. Courts recognize that policing requires judgment, not rigid scripts. This is why two similar situations can produce different outcomes. Discretion feels unfair. One person gets a warning, another gets a ticket. One person is detained, another is released. But discretion is unavoidable. The law does not demand equal outcomes. It demands lawful processes. Legally, police encounters fall into three main categories. Understanding these categories is critical. 1. Consensual encounters. In a consensual encounter, police may approach you, ask questions, request cooperation. You are free to decline, walk away, remain silent. No suspicion is required. If a reasonable person feels free to leave, the Constitution is not triggered. This is where many misunderstandings begin. 2. Investigatory detentions, also known as temporary detentions. Police must have reasonable suspicion that a crime has occurred, is occurring, or is about to occur. Detentions are limited in scope, limited in duration, purpose-driven. They are not arrests, but they are seizures under the Constitution. 3. Arrests. An arrest requires probable cause. Probable cause means a fair probability. Based on facts that a specific person committed a crime, arrests dramatically expand police authority. Understanding when detention becomes arrest is legally critical. Reasonable suspicion is not a hunch. It must be based on observable behavior, specific facts, rational inferences. Courts allow officers to rely on experience, but not stereotypes. This standard allows brief investigation, not unlimited power. Probable cause does not require certainty. It requires probability. This means police can be wrong. Arrests can be lawful, even if charges are dropped later. The legality of an arrest is judged at the moment it happens, not by the outcome. Why? Just following orders is not a defense. Officers are responsible for their actions. Unlawful orders do not excuse constitutional violations. This is why training matters, policies matter, individual judgment matters. But courts also recognize split-second decision-making. This tension defines police law. Police encounters are rarely resolved on the street. They are resolved later. In court, through suppression hearings, through civil lawsuits. The courtroom, not the confrontation, is where legality is decided. This frustrates many people, but it is by design. Police are not legally required to educate you on your rights in real time, explain their legal reasoning, justify every step during an encounter. Silence or minimal explanation does not equal illegality. This is one of the hardest realities for people to accept. Many lawful police actions feel invasive. Stops feel intrusive. Questions feel accusatory. Searches feel violating. But discomfort is not the legal standard. Unreasonableness is. Courts evaluate lawfulness, not feelings. Short clips remove context, preceding behavior, legal justification. Courts see full timelines. Viewers see fragments. This gap fuels misunderstanding and outrage. People who understand police authority stay calmer, avoid escalation, protect themselves legally, make better long-term decisions. Knowledge does not eliminate power imbalance, but it reduces risk. Many believe explaining themselves helps. Legally, it often does not. Statements can be misinterpreted, be incomplete, be used selectively. The law protects silence more than speech. This is not advice. It is legal reality. Police authority is real. It is broad, and it is limited. Those limits do not disappear under stress, but they are enforced later, not instantly. If you interact with police in your lifetime, chances are it will happen in a car. Traffic stops are the most common form of police contact in the United States. They happen every day. They happen to ordinary people. And they happen in moments of routine, not criminal intent. Because they are so common, traffic stops have shaped much of modern constitutional law. They are controlled encounters, but they are also high-risk, high-authority situations. Understanding what the law allows during a traffic stop is essential. Legally, a traffic stop is considered a seizure under the Fourth Amendment. That means constitutional protections apply. However, it is a temporary and limited seizure. Police are allowed to stop a vehicle if they have reasonable suspicion or probable cause. Most traffic stops are based on probable cause, a specific traffic violation. Once the stop begins, the clock starts. A traffic stop must be related to its original purpose. This includes addressing the traffic violation, checking license, registration, and insurance, running basic records checks, issuing a warning or citation. Once these tasks are completed, the stop must end. Police may not extend the stop to investigate unrelated matters unless new legal justification arises. This principle is central and frequently misunderstood. During a lawful traffic stop, police may legally require a valid driver's license, vehicle registration, proof of insurance failure. To provide these documents can itself be a violation. This requirement is not optional. It is part of the regulatory authority of states over driving, which is considered a privilege, not an absolute right. Police often ask questions during traffic stops. Common examples include, where are you coming from? Where are you headed? Do you know why I stopped you? In most cases, you are not legally required to answer these questions. However, Silence does not end the stop, and silence does not prevent further investigation if other legal grounds exist. This is where legal rights and practical outcomes diverge. One of the hardest parts of a traffic stop is distinguishing requests from commands. Legally, police may ask questions without suspicion, request consent without justification. They may not issue commands without lawful authority. But in real life, tone and authority blur this line. Our courts determine legality later, not in the moment. Police may legally order drivers out of the vehicle, passengers out of the vehicle. This authority exists regardless of the seriousness of the offense, suspicion of additional crimes. Courts justify this based on officer safety. This power surprises many people, but it is well-established law. Police may conduct a limited frisk if they have reasonable suspicion that a person is armed and dangerous. This frisk is limited to a pat-down for weapons. It is not a full search. The purpose is safety, not evidence collection. Cars receive less Fourth Amendment protection than homes. This is due to mobility visibility. Regulation. Police may search a vehicle if they have probable cause that it contains evidence of a crime. A warrant is generally not required for vehicle searches when probable cause exists. This is one of the most significant exceptions to warrant requirements. Consent searches are extremely common during traffic stops. If you consent, a warrant is not required. Probable cause may not be required. The scope depends on what you agreed to. Consent must be voluntary, but courts interpret voluntariness broadly. This makes consent a powerful legal tool for police. You are legally allowed to refuse consent. Refusal is not a crime, is not evidence of guilt, cannot legally be punished. However, refusal does not end the stop, prevent further investigation, block a search if other legal grounds exist. Understanding this prevents unrealistic expectations. Police may use drug-sniffing dogs during traffic stops, but with limits. A K9 sniff is not considered a search, may be conducted during a lawful stop. However, police may not prolong the stop solely to wait for a dog. Delay the stop without independent justification. This distinction matters greatly in court. If a lawful arrest occurs during a traffic stop, police may search the person arrested, the immediate area within reach. This authority exists regardless of the original reason for the stop. The arrest itself triggers expanded search powers. If a vehicle is lawfully impounded, police may conduct an inventory search. This search is administrative, not investigative, intended to document contents. Courts allow this to prevent theft claims and ensure safety. However, it must follow standardized procedures. Passengers are also seized during traffic stops, and police may request identification depending on state law. Order passengers out of the vehicle. Passengers are generally not required to answer questions unless legally obligated by state law. This area varies widely by jurisdiction. Some states have stop and identify laws, others do not. In states with such laws, individuals may be required to identify themselves during lawful detentions. In states without them, refusal may be lawful. Federal law does not create a universal ID requirement. During a stop, police may run license checks, check for warrants, verify registration status. These checks are considered part of the stop's mission. However, excessive delay without justification can render the stop unlawful. Courts scrutinize the duration of the stop, the sequence of actions, the justification for delays. A stop that begins lawfully can become unlawful if extended improperly. This is a critical but subtle legal point. Body cameras provide evidence accountability context. but they do not guarantee outcomes. Video does not replace legal analysis. Courts interpret footage through legal standards, not emotion. Several myths persist. Police must tell me why they stopped me immediately. I must answer all questions. Refusing consent ends the stop. Silence makes me suspicious. These beliefs often cause frustration and escalation. The law does not work this way. Courts give police leeway during traffic stops because vehicles are unpredictable. Stops are dangerous. Decisions happen quickly. This leeway is not unlimited, but it is real. Understanding this explains many rulings people find surprising. Most disputes over traffic stops are resolved later through motions to suppress evidence, civil rights lawsuits, internal reviews. The roadside is not the courtroom. This separation is intentional. Courts consider compliance behavior, tone context. Calm behavior reduces ambiguity and legal risk. This is not about submission. It is about protecting yourself legally. Traffic stops feel routine, but legally, they are complex encounters. Governed traffic stops feel routine, but legally, they are complex encounters governed by layered rules, exceptions, and standards. Police authority during traffic stops is real, but not unlimited. Understanding what is required, what is optional, and what is prohibited changes how people experience these encounters. There's a moment in some police encounters when everything shifts. The tone changes. The authority increases. The legal stakes rise sharply. This moment usually occurs when an officer believes a crime has occurred, or safety is at risk, or control must be asserted. From this point forward, constitutional limits still exist, but police power expands dramatically. Understanding this transition matters. Searches are one of the most invasive actions the government can take. They involve physical intrusion, exposure of private property, collection of evidence. Because of this, searches are heavily regulated by constitutional law, but regulation does not mean prohibition. As a general rule, searches require a warrant issued by a judge. The warrant must be based on probable cause, oath or affirmation, specific description of what is to be searched and seized. However, modern policing relies heavily on exceptions to the warrant requirement. These exceptions are lawful and widely used. Consent eliminates the need for a warrant. If a person voluntarily consents to a search, no warrant is required. Probable cause may not be required. The search is generally lawful. Consent may be withdrawn, but anything already observed may still be used. Courts interpret consent broadly, especially when it appears cooperative. The scope of a consent search depends on what a reasonable person would understand they agreed to, the words used, the context of the request. For example, consenting to search a vehicle does not automatically mean consenting to search closed containers, unless reasonably implied. These distinctions are resolved in court, not on the street. Once a lawful arrest occurs, police may conduct a search incident to arrest. This allows officers to search the person arrested, areas within immediate reach. The purpose is officer safety, evidence preservation. This search does not require a warrant and happens automatically after arrest. Exigent circumstances allow warrantless searches when evidence may be destroyed, a suspect may escape, someone may be harmed. These situations are narrowly defined, but courts often defer to officers' on-scene judgment. Exigent circumstances are one of the most litigated areas of search law. Police may seize evidence without a warrant if they are lawfully present. The evidence is immediately apparent as contraband or evidence. They have lawful access to it. Plain view does not justify entering a space unlawfully, but once lawfully present, Observation is not restricted. Vehicles are subject to broader search authority than homes. If police have probable cause that a vehicle contains evidence of a crime, they may search the entire vehicle containers within the vehicle without a warrant. This authority exists even if the driver is already detained or arrested. The rationale is mobility and the reduced expectation of privacy in vehicles. The home is treated differently. Warrantless entry into a home is presumed unreasonable unless consent is given. Exigent circumstances exist. Hot pursuit applies. Courts scrutinize home searches more strictly than any other type. This reflects a core constitutional principle. The home is the center of privacy. An arrest is the most significant seizure of liberty outside imprisonment. It requires probable cause. Probable cause is evaluated based on what the officer knew at the time, what a reasonable officer would believe. The totality of the circumstances arrests can be lawful even if charges are later dropped. Legality is judged at the moment of arrest, not the outcome. Handcuffs, detention, and de facto arrests. Not all handcuffing equals arrest. Police may handcuff during detention if officer safety is a concern, the situation is volatile, the detention remains temporary. However, prolonged restraint may transform a detention into an arrest. Courts analyze duration, restraint, and purpose to decide legality. Police are authorized to use force. The legal standard is objective reasonableness. This means force is judged based on the severity of the crime, the threat posed, whether the suspect is resisting or fleeing. Courts do not require perfect decisions. They require reasonable ones. Courts evaluate force from the perspective of a reasonable officer. At the moment force was used, without the benefit of hindsight. This standard is controversial, but foundational. It explains why force that appears excessive later may still be lawful. Batons, tasers, pepper spray, and physical restraints are all forms of force. They are regulated, but permitted when justified. Each use is evaluated individually. Repeated or unnecessary force can render an otherwise lawful arrest unconstitutional. Deadly force is permitted only when the officer reasonably believes there is an imminent threat of death or serious bodily harm. This standard applies regardless of the suspect's guilt, the suspected crime. Deadly force cases receive intense judicial scrutiny. Resisting arrest, even unlawfully, often leads to additional charges. Many states prohibit physical resistance, even if the arrest is later deemed unlawful. Courts generally expect challenges to be resolved after the fact, not during the encounter. This reality surprises many people, but it is legally significant. Asserting rights does not end police authority. It does not prevent detention. It does not prevent arrest. It does not override probable cause. Rights operate through courts, not declarations. This misunderstanding fuels many confrontations. After arrest, constitutional protections increase again. This includes right to remain silent, right to counsel, judicial review, bail considerations. The arrest is not the end of the legal process. It is the beginning. The most common remedy for rights violations is suppression of evidence. If evidence is obtained unlawfully, it may be excluded from court. This is how constitutional limits are enforced in practice. Individuals may sue for violations of constitutional rights. These cases are complex and difficult, but they are a key accountability mechanism. They do not erase harm, but they impose consequences. Officers may be protected from civil liability unless they violated a clearly established constitutional right. This doctrine is heavily debated and evolving. Understanding it explains why accountability is rare, but not impossible. Police law prioritizes order, safety, stability. Individual rights are protected, but within that framework. This balance frustrates many people, but it is intentional. Many legal disasters stem from escalation assumptions, false beliefs, emotional reactions. Knowledge does not eliminate authority, but it reduces harm. Searches, force, and arrests are where the law becomes most visible and most unforgiving. Police power is real. Its limits are real. But those limits are enforced through process, not confrontation. In the final part of this episode, we'll step back and examine the bigger picture. We'll talk about common myths that keep repeating, why misunderstanding police law is so widespread, and what legal literacy actually provides, and what it does not. Because knowing the law is not about control. It is about clarity. By now, one thing should be clear. Police authority in America is not simple. It is layered, conditional, and heavily shaped by court interpretation. Yet most people approach police encounters with confidence based on ideas that are incomplete or wrong. This gap between belief and reality is not accidental. It is the result of how people learn about the law. Popular culture has shaped a powerful myth of police encounters. In movies and television, officers explain themselves clearly. Rights are read immediately. Saying the right phrase stops authority. Justice is instant and visible. In reality, officers are not required to educate you. Rights are enforced later, not instantly. Authority does not disappear when challenged. Legal remedies take time. This disconnect creates frustration, fear, and escalation. Myth. Number 1. If I know my rights, police can't do much. Knowing your rights does not eliminate police authority. It does not prevent, stops detentions, arrests. Searches supported by law rights do not function as shields in the moment. They function as limits that are enforced through courts. This is one of the hardest truths for people to accept. Myth number 2. Police must always explain themselves. Police are not legally required to explain every decision, cite legal standards, justify actions in real time. Silence or minimal explanation is not evidence of illegality. Courts evaluate actions later, using facts, not dialogue. Myth number 3. If it feels wrong, it must be illegal. Many lawful actions feel invasive. Being stopped feels accusatory. Being searched feels violating. Being detained feels unfair. But the legal standard is not comfort. It is reasonableness. Courts do not ask whether something felt fair. They ask whether it violated constitutional limits. Myth number 4. If police break the rules, you go free. This belief causes more disappointment than almost any other. A rights violation does not guarantee. Charges will be dropped. Arrests will be invalidated. Immediate consequences for officers. The most common remedy is suppression of evidence, not dismissal. Rights protect process, not outcomes. Many people ask why rights are not enforced instantly. The answer is simple, but uncomfortable. Instant enforcement would require on-the-spot legal judgments, perfect information, zero risk to safety. The system prioritizes order first, review later. This is not ideal, but it is intentional. Courts recognize that police operate in unpredictable environments, time pressure, potential danger. Because of this, courts allow officers reasonable mistakes, split-second decisions, broad discretion. This deference is not unlimited, but it is real. Understanding it explains many court rulings people find frustrating. Some actions are legal, but unwise. Some actions are wise, but not legally required. For example, You may legally remain silent, but silence may not end an encounter. You may legally refuse consent, but refusal may not prevent a search on other grounds. Law defines permission, not strategy. Courts evaluate encounters holistically. They consider tone, compliance, resistance behavior over time. Escalation increases. Use of force, legal exposure. Ambiguity. Calm behavior reduces risk, even when rights are later challenged. This is not about submission. It is about protecting yourself legally. Recording police is often legal and useful, but recording does not. Change authority in the moment. Prevent enforcement. Guarantee accountability. Video is evidence, not immunity. Courts interpret footage through legal standards, not emotional reactions. Viral clips often show the end of an encounter, a reaction without context, force without the preceding events. Courts see the full timeline. Viewers see fragments. This mismatch fuels outrage, not understanding. Police law often appears to favor authority. This is because the system prioritizes safety, stability, predictability. Individual rights exist within that framework. The Constitution restrains power, but it does not eliminate it. Legal literacy does not give you control. It gives you clarity, realistic expectations, better long-term decisions, fewer irreversible mistakes. It replaces myths with understanding. Legal literacy does not guarantee fairness, prevent inconvenience, stop lawful authority, eliminate consequences. It improves outcomes over time, not in every moment. The American legal system assumes something fundamental. Power is dangerous, but necessary. Police authority exists to maintain order. Rights exist to limit abuse. The tension between the two is permanent. There is no final balance, only continuous adjustment. The street is not where legality is decided. The courtroom is. This is why lawyers matter, evidence matters, procedure matters. Rights live in institutions, not arguments. Understanding police law should lead to less escalation, fewer assumptions, more patience, better decisions. Not fear, not anger, not confrontation. Clarity. Police encounters feel personal, but they are governed by systems. Those systems are slow, imperfect, procedural, but they are designed to strain power over time, not eliminate it instantly. This perspective changes how people experience authority. If you've watched this entire episode, you now understand something most people never fully grasp. Police authority in America is real. Its limits are real. But those limits are enforced through law, not confrontation. Knowing the law does not make you powerful in the moment. It makes you prepared in the long run. That is the purpose of American Laws Explained. This channel exists to replace legal myths with clarity, calmly, carefully, and without political noise. If you want clear, long-form explanations of American laws, rights, and government power, subscribe. Upcoming episodes will explore free speech and where it truly ends. What happens after an arrest? Legally. Marriage, divorce, and family law. Explained military and emergency powers. Federal law versus state authority. No fear, no exaggeration, just the law. Explained. If this episode added clarity, leave a comment with the next law or right you want broken down. And if you want to stay informed, not confused, subscribe to American Laws Explained, because understanding the law doesn't require confrontation. It requires clarity.